Thank you, everyone. Please be seated. We are here in the matter of 2 oral arguments this afternoon, but before I get to that, I also need to announce that we have 2 cases that will be submitted at this time without oral argument. The first case is State of Iowa versus Alexander Shantee Thomas Ross. That is hereby submitted without oral argument. And the same is true for the matter of Copeland versus State of Iowa and Iowa Air National Guard. Those 2 cases are submitted without oral argument. And we will proceed to our first oral argument of the afternoon, Guardianship of J.W. And it looks like the parties are ready to begin. Is that correct? Thank you. You are Alexis? You may begin.
The optics are bad here. That's what Judge Greer said about this case. But it's not just the optics that are bad. It is bad here. We're here today because a licensed attorney in Iowa is attempting to forcibly take custody of a repeat client's daughter through disclosure of information obtained during the attorney-client relationship. The court should not and cannot allow a legal action to proceed when the action itself is initiated with the disclosure of privileged information, and continuation of the proceeding would necessitate additional ethical violations simply to meet the filer's burden of establishing a prima facie elements of the cause of action.
Different theory, than what the Court of Appeals said it states a claim. You're saying maybe it states a claim, but you've got another theory as to why the case shouldn't go forward. Do you have a legal authority for that, Ms. Dahlhauser?
I was researching this case on whether or not it could move forward. You're correct. The Court of Appeals viewed it as that there was a claim. I don't believe that there's a claim, but my position is that even if there is a claim, Mr. Van Cleef would not be entitled to move forward. When I was researching the legal authority on that, I came up kind of slim. It was a very specific situation that I'm trying to research here. I did find some case law that discusses the appropriateness of an attorney being disqualified based on ethical.
So let's say if it states a claim, if they've pled the elements for an involuntary guardianship, and let's say hypothetically Rule 1.945 doesn't cover this situation. There wasn't necessarily a violation of a court order or a rule in the rules of civil procedure. Then, what's the grounds for dismissal? Where do we get a ground for dismissal?
Even if we are considering this as a motion to dismiss, I believe that he failed to make a claim, given that the facts in the light most favorable to Mr. Van Cleef still show that mom was parenting, and even in the Court of Appeals background and facts, they cite Van Cleef claimed he and Wilt had acted as de facto guardians, and then goes on to say, when not actively prevented from doing so.
Your position that the alleged ethical violation alone is grounds for dismissal?
No, Your Honor. I am adding to that there are numerous grounds for dismissal. I think that it fails to state a claim, but even if there is a claim, as the appellate court seems to think, that it would still and should still be dismissed based on the ethical grounds alone.
District Court rule on your other theory?
We did not even begin to discuss the merits of the case or whether there was a claim. My position all along has been that there was never a motion to dismiss, so we didn't consider whether or not a claim had been made. We only discussed at the district level whether or not Mr. Van Cleef could move forward in any form or fashion.
Facts, right? So your client is the child's mom.
Correct.
Just call her mom. That used to be his client too.
Several times.
The issue of custody of the child at issue.
Other children.
And now he's an attorney here today, but also the party who is asking to have involuntary guardianship of his former client's child.
Petitioner and the proposed guardian.
Okay. All right, you can go on.
In the case involving this particular child, if I understand it correctly, and please correct me if I'm wrong, that was resolved by default judgment. Is that correct?
One of them was, I believe it was the one involving this child.
Difference in terms of the alleged ethical violation if the case wasn't actually litigated?
Litigation began. There was information that he obtained through that. He had knowledge of contact with the father in that case that was cited in this guardianship case and used and referenced. Furthermore, even the siblings' cases are relevant, and those were heavily litigated. One was even modified and litigated again.
Trump's best interest of a child? Okay, so if best interest of the child, especially in a case such as this, is a motion to dismiss, if we would just assume that the facts were true and that maybe this child is in danger?
That's a good question, Your Honor, and it's something that we and the district court already addressed. In the end of Judge Price's ruling, you'll see that we discussed that we still needed to look out and provide for the safety of this child. So he ordered the court visitor in the guardianship case to consult with the Department of Health and Human Services to do an assessment to see if that was necessary. I would argue that there's no need for a guardianship. I would argue that this child is safe at home, as evidenced by the fact that we're only after a petition for one child and not all of her children. But even if that weren't the case, the guardianship is not the way to protect this child.
Puzzled and troubled by the district court order, though. It says that the petition's dismissed. And then it said, okay, drop a dime on what's been going on. But it dismisses it. So there is no judicial supervision or it's not like there's a pending China or anything, right?
Evaluation for a China. Correct.
A directive to conduct an evaluation, and it's up to the department whether or not they want to take it another step, and then it's up to the county attorney to decide whether or not he or she wants to file. So the district court order just plain flushed it, right? With some caveats to please contact authorities.
Agree. There was follow-up that's not within this that the Department of Human Services met with this family. My client participated with that. The court visitor provided the information to the department. So there was follow-up. Your Honor, I can't speak to whether Judge Price did continue to monitor it.
Dismissed cost tax to petitioner.
He did not have an open case to assess it. Had a China been filed, he would have, or another guardianship could have been filed with someone that's more appropriate to bring that action.
What's the specific alleged ethical violation you're claiming here?
Your Honor, I cited several in my enumeration. The ones that are particularly worthy of warranting the dismissal, because it's not my position that every ethical violation warrants a dismissal. It's my position that these ethical violations I believe they were Rule 32 1.7 and Rule 32 1.9 and Rule 32 1.10. As we sit here, and as was evidenced when Mr. Van Cleef went under oath and provided affidavits, and even within the petition itself, he used facts that were garnered through his representation, that he got through the confidential information to even state a claim. Then when it went forward to proving that claim, he doubled down.
Did he gain uniquely through the representation that are in the petition?
Facts alleged in the petition about father's parenting capacity, and stated that he was aware of his lack of participation in other cases involving him, presumably the custody case. He discussed the history of
About the father, not the mother that he represented.
about their interactions together and their ability to co-parent. He discussed mother's paramours. He discussed her ex-relationships, and these are all people that he has represented her. And
When we talk about the ethical violations, there's sort of two categories, it strikes me. One is sort of the conflict of interest stuff like Rule .9 and some of the other ones you've cited. don't those require him now to be acting in capacity as an attorney, which he's not doing? He's just acting for himself.
Your Honor, yes and no. It is required when you're acting as an attorney. So a layperson off the street, these rules are not going to apply for. However, when you are an attorney and when you are sworn into the bar, that's not a hat that you can take off.
Just as when you represent someone and that representation is a conflict with some other representation. Right now, he's not doing a representation. So how is that a violation of the conflict of interest? We've got another set of rules I want to talk about, but in terms of the conflict of interest rules, I'm a little puzzled as to how those would be violated now.
Himself. And while I understand that that's not a separate party, because he's an attorney, he doesn't take that hat off, and he has that information and that responsibility from the bar.
Separate set of rules. So those are the rules that say the 1.6 and 1.8 that say you shall not reveal information relating to the representation, shall not use information relating to the representation of a client to the disadvantage of the client. Those seem like rules that might potentially be applicable here as opposed to all the conflict of interest rules.
That was discussed. Mr. Van Cleef's legal assistant was still a co-guardian, and she still is a proposed co-guardian.
The petition that he wrote refers to himself as co-petitioner Jacob Van Cleef, and then paragraph 3, co-petitioner Amelia Wild.
And we had lengthy discussion at the beginning of the district court case whether or not he was representing Miss Wilt. My position was and still is that he was representing her. He said he was not. The district court went along with that. So she was dismissed as a co-petitioner and remained as a co-guardian.
Hypothetical of you. Let's assume you had a lawyer who represented a client in a dissolution proceeding where a child was at issue. And at the end of that litigation, the lawyer and the client enter into a relationship. They ultimately get married. And then the lawyer files for divorce. And now he's fighting for custody of the child in that dissolution proceeding. Is that prohibited by the rules? And if not, why is that different than what's going on here?
That's actually a hypothetical that I considered. And it's different because there is a claim. Mr. Van Cleef's position throughout all of this has been that he has a claim, and if mother didn't want sued, she shouldn't have been a bad mother, and that gave him a claim. So in that situation, what's different is they're getting a divorce. That is a claim. That is a situation where they're looking for custody, so that's what makes it different.
Rules, does it talk about the merits of the underlying claim in terms of evaluating conflicts of interest and revealing information?
It doesn't discuss whether or what breakdown of which claim is appropriate. But in the situation, in the hypothetical that you described, there is a claim that is not one that arguably that gentleman or female had created of his own volition. There was a divorce. I was a no-fault state. There was a claim in and of itself. The difference here is Mr. Van Cleef sought this out. He initiated and pursued this claim.
Or initiated the divorce. I mean, what's the difference? In terms of the ethical rule, I don't see the distinction between these two cases. And maybe you have to analyze whether it's substantially related representation under 1.9, but it doesn't seem like there's a per se prohibition on a lawyer being involved in litigation with a former client, even where it relates to something that the lawyer was involved in previously.
I think you're correct. There is no specific ban on that, though I would argue that in this set of circumstances, there should be.
The problem with that is it says, again, if you may not agree with me, but if you put aside the conflict of interest, and we're talking now about using information to the detriment of your client or revealing information relating to the representation, that's the 1.6 and the 1.8 rules that apply whether you're acting as an attorney or not. Those are the ones that I think might be applicable. They have an exception, like Justice McDonald pointed out, if you're establishing a claim, if you're trying to establish a claim. So why doesn't that exception apply here? It doesn't say, it doesn't, kind of limit the types of claims. It doesn't say only if you're trying to collect a fee or something like that. It just says a claim, right?
It also says that there is, that an attorney can do this for a claim or an action in defense. The plain reading of that is that this, a lawyer, and it goes into this when it discusses attorney fees, which is what Mr. Van Cleef heavily relied on in the underlying case. If someone is accusing you of something, or if you are personally wronged, you have the right as an attorney. You shouldn't come out net negative just because you're an attorney. The difference here is that he was whole already. Nothing had wronged him.
Why is it so important that that it's an exception to 1.6 and I assume 1.8 to collect a fee, but not to protect a child? What's the difference there?
I see my time is up. Can I answer your question?
You too.
My position, and what I would argue is the correct position, is that it's not about protecting the best interest of the child. I agree that that is fundamentally important. I think that there are other avenues to pursue that, as evidenced by the district court and as evidenced by another person could seek a guardianship. The difference here and what's important here is that Mr. Van Cleef is equating this child to collecting a fee. He has no right to this child. Nobody wronged him. There is no relief in this. He was already whole. The relief is the custody of a child that a parent has a constitutional right to parent.
Sorry, Chief, can I ask another? But isn't that the merits question? I mean, you're kind of assuming, as I understand your argument, it's we should win because I think we should win if we got a ruling on the merits. He's filed a petition. He stated a claim that's recognized under Iowa law. I don't see anything in the ethical rules that carves out the categories of claims that lawyers can seek to pursue on their own behalf. And it seems like your answer is well, he's just not entitled to this because at the end of the day, he's not going to win the case.
Correct. He's not entitled to this, and it's my position he wouldn't win, even if we went back on the merits. But that's not why we're here today. We're here today because this sets a precedent not just for 232D or 232 cases, but cases where an attorney is using confidential information garnered through representation to further his own personal benefit. The reason that this is important today is because if we were to allow this to continue, there's an immense amount of additional harm that would happen to my client, to Mr. Van Cleef's repeated client, to who has been waiting 2 years to know if we have to actually argue the merits, to her daughter who is anxious about losing her home, to other clients of Mr. Van Cleef's that he may decide that he has an interest in their children, to the judicial effectiveness and the trust of a layperson in their attorney. It's incredibly important that someone be able to walk up to their attorney and trust that what they're saying is going to be held in confidence and not used against them later. That is why it's important, because there's no way forward in that case that Mr. Van Cleef can proceed without continuous ethical violations, regardless of the merits.
Back to you in a moment. Mr. Van Cleef. I started off with your opposing counsel. Can you tell why I said that out loud? Okay, so your client used to be his client, and the child at issue, you're now in a case trying to get guardianship of that child against your former client's wishes. Can you see why I'm kind of plugging my nose? Can you tell me that I'm wrong, or is that really how it is?
That is the facts. The context in which those facts occur is, I would argue, would make the facts less odious as it is learned. But if you're looking for just a narrow breakdown of the facts, yes, I am seeking to obtain guardianship over a former client's child.
My review of the file is that nothing that you garnered or gathered during your confidential relationship has been used against her. Is that correct?
That is essentially my argument, and also that I believe it's possible to make my burden without making use of that information.
One hypothetical to give you, not hypothetical, but a concern I have. I had many, many clients, probably hundreds of thousands. I remember the relationship I had with my clients. They tell you stuff knowing it's between you and me, nobody else. So even though you may not have used a confidential communication, it's not a stretch to imagine she told you something that she's scared to death you're going to say. Isn't that a possibility? You may not have said it yet, but you possess something that she knows you possess, and isn't that inappropriate?
I believe the rules don't, it would indicate that it's not inappropriate, but it isn't absolutely something that she could fear.
I took some time with Ms. Dahlhauser. Now, Mr. Van Cleef, I want to focus in on what maybe bothers me about your position. I do read 1.6 and 1.8, the rules about not using information learned during a representation of a client to the detriment of the client or revealing that information, except to establish a claim, and you're establishing a claim. So that we have that. But I still think 62210, the attorney-client privilege, as far as privileged information, the kind of things the Chief was talking about, something that was spoken by the mom to you in confidence, that might still be something that you, under no circumstance can you take advantage of or use that for any purpose. And I have trouble seeing how you can separate yourself from what you might have learned in terms of attorney-client privileged information. Do you see my concern? Can you respond to that, sir?
Not only that, I understand it, but the procedure, the response for that should not be to categorically deny me access to the court. It should be to set up a procedure or system by which the information I intend to use, the arguments I intend to make, and other such information can be vetted by an officer of the court, perhaps a special master, so that this person's rights can be protected while I'm...
Lawyer.
Seems like the same problem with extra steps. I tell them the information I have, they go and use the same information at trial.
Attorney-client privilege if you told them what you know. You can't tell your client, I mean, you have attorney-client privilege with your client, but do you think you can breach something in a confidential conversation?
I had not considered that possibility.
At a lawyer, you could communicate with the lawyer and you could tell the lawyer only information that you may have learned during the representation, but that's not attorney-client privilege. Something, let's say something happened in open court and you saw it and you observed it, you wouldn't have learned it if you hadn't represented mom, but it's not privileged. That could be something you could pass along to the attorney, but you couldn't pass along to your attorney what you had actually been discussing confidentially with mom.
Fair and rational analysis, and it would protect the rights of the mother. The only issue there is that it then burdens me with the cost of having to file for such an attorney.
I mean, again, you know, yeah.
About if it costs you a little bit of coin in your pocket, to prioritize the best interest, isn't that what we're supposed to look at, even if it means you have to pay a little bit of money?
So long as it doesn't infringe upon my constitutional right of access to the court, and if it makes the cost high enough that it prevents me or deters me from filing the action, then I think there's an issue.
A constitutional issue, a fundamental right to raise your children, make decisions, things like that. So we have other competing constitutional rights, perhaps?
Perhaps.
Mr. Van Cleave, I want to take us back to the idea that you have a claim. You can use the information to establish a claim of the lawyer in a controversy between the lawyer and the client. And so what's your answer to your opposing counsel's view that you have created a controversy to the extent that there was a controversy between you and your former client?
I would argue that in order for us to have a controversy, there would have to be an interaction from both parties. I'm capable of creating one by myself.
So can you expand on that? So what is the controversy between you and your former client?
The controversy between myself and my former client at this point is I've alleged that she has failed to act as a parent for a prolonged period of time, allowing other people.
People are going to start suing all their clients. How many of our clients have done the wrong thing? And we try our best to get them the best deal in court we can. And then for us to, I mean, can you imagine, take that down the path of anything? A personal injury, suppose somebody tells you, I actually did run the red light, but let's make them, whatever. I mean, all of this information we know, we could use against our clients. We're always hearing stuff from our clients about what they did and probably shouldn't have.
I'm not sure that I follow, Your Honor. The issue here.
Just made a comment about what you learned, you felt obligated to take it to the next level. Wouldn't that be true of most every case we deal with?
Obligated doesn't affect whether or not you have standing and meet the requirements under the code or under the common law in order to have an actual claim or action. Here, I've enumerated all the reasons for which I do. Just because you've heard that your client behaved in an improper fashion doesn't mean that you have a claim. It just means that you've heard something.
Van Cleef, earlier you said that this kind of short version of the facts depends on context. Based on the pleadings that we have now on this record, what is the additional context that prompted you to seek to intervene or seek guardianship of this child?
If directed to answer, I'll answer, but my understanding is that we're not supposed to introduce new facts at this point.
Based on this record, what is the context motivating your petition to seek a guardianship over this child that isn't captured by the previous summary of facts?
I would argue the length and nature of the relationship between parent and child, the manner in which the child came to be in the care of de facto guardians, and the choices of the mother post-representation in relying or allowing the de facto guardians to act as such.
And as a de facto guardian based on this record, again, don't tell us about anything that's not in the record yet.
The child into my home, originally provided relief to the person who was originally acting as the de facto guardian, began to parent the child, took the child into my home, and essentially for a period of time raised the child. For how long? Provided relief to the original de facto guardian, I'd say about 2 years, maybe a little more. That began in, I believe, 2017. To take the child into the home, not every day, obviously, but for weekends regularly, starting in, I'd say, 2017. Or 20, I'd have to look at a calendar.
With the consent of the mother? Okay.
Imagine falling in love with my client's situation or their child, or feeling really, really bad and my heart breaking and wanting to reach out to them. I think we've all been there where we've probably gotten a little too close to our client's situation, heartbreak. Maybe you want to throw them a few bucks to help them make the rent, whatever it may be. We've all been there. But in hindsight, do you think you took the approach that is in the child's best interest to entangle yourself with a litigation against his mother, your client?
Her mother. In hindsight, I would not have been involved in any of this. Hindsight's 2020.
Justice Mansfield said, wouldn't it have been real simple when your heart's breaking, you feel bad for the kid, and you think things are really going south, and the home is not providing what they should? We all have friends in the biz. Pick up the phone and say, hey, Dana, you know what? Can you help me out here? Can you help a family that needs a guardianship case worked out? Does that sound like possibly a solution that would make more sense than what happened?
In this case, given that there was Ms. Moore exists as a potential co-guardian, yes. However, I believe that based upon the child having lived with me for a number of months at that point, rather than being in Ms. Moore's home, that I was the individual with the best standing.
According to your petition, you declare her as co-petitioner, correct?
At that point, yes, but I believe as
There's a written document here that's filed in court that says co-petitioner you and then co-petitioner her. So she was your client and you were pro se. Wouldn't that be true? Why did you say that in a sworn document?
At that point in time, as I explained in the original hearing, Ms. Moore was intending to seek to file an action herself. I put that on there so that she could, to avoid having numerous filings addressing the same issue. I thought that I was saving the court time and energy, but no, I have not represented Ms. Moore. Sorry, Wilt. Her marital last name is Wilt.
Counsel is, or Mr. Van Cleef, is this case moot? It's been 2 years since you filed the original petition. Are the issues still to the point that we could send this back as the Court of Appeals ordered?
I believe so.
Can you clarify that for me? Do you think it's moot, or do you think there's still a live case that could be sent back?
If it was moot, it's worth making a decision so that future attorneys know how to govern themselves in these unfortunate types of situations. But regardless, no, I do not believe it's moot. If it's sent back to the court, I believe that there would be a case worth hearing here.
Special master, how would that solve the problems?
Any information which I wanted to use, I'd have to submit to that individual who would review and determine whether or not there would be any ethical violation from the use of said information.
Would you still have the same problem if you were using confidential information you got from your former client, the mom, and then shared with the special master? Or is your view the special master could then filter out what can and cannot be used?
Can and cannot be used.
All this seems like something that maybe could work with the mom's consent, but not over her objection. It seems the red flags are flying all over the place. You mentioned you wouldn't have gone down this road if you'd known what a mess you'd end up in. Do you want to just bail out now?
I wouldn't have gone down that road. I meant my initial involvement with the child. At this point, this may sound unusual, but I'm invested in having an actual answer one way or another.
Anything else you want to say? You still have 1 minute and 15 seconds.
The question before the court appears to be whether or not I can proceed and whether or not dismissal is an appropriate remedy. And I would argue that as of this point, the opposing party has never offered any authority to indicate that dismissal is the appropriate remedy. In fact, the preamble to the rules of professional conduct indicates or warns against the purpose of the rules being subverted by allowing parties to use them as procedural weapons. I believe that there is a way that with thought and whatnot, and with forethought and effort, there's a way for us to proceed forward that allows the protection of the mom's interest.
If the district court found that you can't represent yourself in this action, and you're the only one that can really bring this claim, then what's the district court to do? Should the court demand that you get counsel? I'm not sure that the court can do that either. What other option does the district court have if the district court finds that you can't represent yourself and you refuse to get counsel to represent you?
I never refuse to get counsel, but if it demands that I get counsel, I would ask or attempt to make an argument that I should be afforded court-appointed counsel.
Would you like to make a summary statement?
Not at this point, Your Honor.
Sir?
Thank you, Your Honors. I'm glad Mr. Van Cleef brought up the preamble of the Iowa Rules of Professional Conduct, because further on down from where he quoted, paragraph 8 says, "A lawyer can be sure that preserving client confidences ordinarily serves the public interest because people are more likely to seek legal advice and thereby heed their legal obligations when they know their communications will be private." The preamble mentions numerous times that the confidences between an attorney and a client are of the utmost importance. And as a matter of public policy, that's true. Mr. Van Cleef pulled out one section of that and is attempting to say that as counsel for mother, I've weaponized this against him. My interests are the best interests of the child, but also the best interests of my client. Those don't have to be different things. The child's interests can be protected, and my client's own interests and her confidences that she had over 5, 6, 7 years of representation by Mr. Van Cleef and his partner at his law firm can still be protected.
Assume that I could be persuaded that the guardianship proceeding should not have been dismissed because just because the people filing it and the parties involved may be a bit dodgy doesn't get away from the premises of this is a child who needs the attention of the court, or at least a review by the court to determine should there be a guardianship. So if there were a remand, what would that look like? What would need to be decided by the court if the guardianship itself should not have been dismissed?
To answer that in two ways. So first of all, hindsight is 20/20. I agree with Mr. Van Cleef about that. If I could go back to the day that we were before the district court judge, I would ask that he postpone the dismissal or keep the guardianship open until there was that case. There's case law, or there is a statute in 232 that says if a guardianship is either going to be established or dismissed, the court should discern whether a China case is necessary. I would ask that the court kept oversight over that. I think what needed to happen did, but I understand the court's concern that it might not have based on the way that it moved forward. If we were to remand, I think that all of the arguments that Mr. Van Cleef made, I know all of the arguments that Mr. Van Cleef made in his petition are moot at this point. He discussed his caregiving of the child, her grades in school, everything down to her hygiene. None of that is relevant 2 years later. Even if it is relevant, it is history at this point, and 2 years is a long time. According to Mr. Van Cleef, 2 years is long enough to now break client confidentiality because it's old news. So I think that it's important to note that even if we go back to district court, I have the utmost confidence in a dismissal of this guardianship case. I agree with the question of, is it moot? Is the guardianship moot? Yes. Is the question before the court on whether or not a dismissal was appropriate in this case moot? No, it's still ripe and it still deserves an answer, because prior to becoming involved with this, I didn't think I would ever find myself in a situation this seemed so clear to me. So I think that the court must provide guidance.
This is kind of the issue I'm struggling with. It seems like the rules provide some allowance for a lawyer to assert a claim or an interest against a former client when there's been the passage of time or changed circumstances, kind of like the divorce hypothetical that we discussed earlier, that the legal relationship between the parties has changed. If that's true, and we do have, at least, or we did have, de facto guardianship at the consent of the mother for an extended period of time, in terms of assessing the ethical violation, and I understand dismissal is a separate issue, doesn't that seem relevant? I mean, can we say that there was an ethical violation when there is some indication in the record that the legal relationship between the parties changed in a material way? That's the issue I'm struggling with.
I appreciate the opportunity to clarify that. The concerns that I have regarding the issue that you brought up are that Mr. Van Cleef, he discusses this proposed co-guardian, that's his legal assistant. So she is bound by very similar rules working in a law office, or at minimum, Mr. Van Cleef is required to ensure that she follows some level of those rules. He alleges that she was de facto guardian in, I believe, 2013, whereas the most recent representation from Mr. Van Cleef was several years later. So yes, relationships change and they progress, but we're not talking about him saying that they became de facto guardians 10 years later when mom fell off the wagon. We're talking about he actively helped this mother get custody of this child while at the same time he's claiming his legal assistant was de facto guardian. That is a problem. And the way that the appellate court reading says is that we must determine the merits of a guardianship prior to eliminating the proposed guardian, and that's a problem. Under the rules of professional conduct, an attorney, a judge is required to bring to attention alleged ethical violations. If we go back to the district court and we say, let's hear the merit first, we don't have to guess if Mr. Van Cleef is going to violate ethics because he already did, and when we had a hearing.
I ask a question on that. You started off with the statement, the optics are bad, a quote from the dissent. You would agree with me, we have lots of ethical cases, including, we have a disciplinary case we're hearing this week as well. It's very important to be very precise about those rules, isn't it? It's not, there are distinctions between information gathered in the course of representation and information that is a client confidence. There's a distinction between representing somebody and being a party, right? And would you agree that it's important that we dissect those ethical claims and really determine where there are, if at all, any ethical violations?
That it's correct that there is a difference. If you were to ask a layperson on the street, if I'm having a conversation with my lawyer, whether it's at a counsel table or in private, if there's a difference, I don't think that they would know that. And what the client considers to be confidential information is important. So yes, there might be some slight difference, but I'm not sure that it would be relevant to this. And if I may just conclude my thoughts.
Dismissal, is it possible that in determining the guardianship issue on the merits, that the lawyer's alleged ethical violations might just be a relevant consideration in terms of whether this person is an appropriate guardian, given his relationship and history with the client and with the child, rather than making this an all or nothing proposition?
I want to make sure I understand your question correctly. Are you asking if perhaps it wouldn't have been better to consider the merits of this particular guardianship first?
Generally, if there's an allegation, as there is here, of lawyer misconduct, and the lawyer is seeking to be the guardian, could that be a relevant fact for the district court in assessing who should be the guardian, rather than just dismissing the entire case without actually getting to the merits of the case?
I think it was a factor in this case. And when we had an entire day's worth of hearing and testimony and evidence presented and affidavits submitted, the district court judge was considering the previous relationship, the nature of that relationship, and whether or not this person could be a guardian. If we let that play out and we say, okay, let's consider the merits. Maybe Mr. Van Cleef has made an excellent claim, we do need a guardianship. Then we have to say, well, okay, can he be the guardian? And then we have that evaluation. We did that first. The judge said, no, he can't. So let's assume that the judge makes the same finding. So now we have a situation where, okay, we need a juvenile guardianship, but now we don't have a guardian. Without a petitioner and without a guardian, we don't have anything left. So the recourse would have been the same, that the judge would say, please see if DHS wants to do this as a China case.
If you'd like.
Make it brief. I see I'm over time. Your Honors, what I think is the most important thing to take away is it doesn't matter how we get there, it's improper. Each of you may have a different opinion of how we come to the resolution that this is inappropriate, but one thing that I think is clear is that it is inappropriate, and not just inappropriate, it's not allowed to move forward or shouldn't be. So I'm asking this court to use its inherent power as a matter of public policy, as a matter of judicial efficiency, to say this isn't allowed. Jacob Van Cleef cannot force involuntary guardianship of his repeat client's child. So I implore you to avoid setting a harmful precedent for cases where maybe the facts aren't so clear and there isn't the level of confidence at the district court. Thank you, Your Honors.
Case of Guardianship of J.W. is hereby submitted, and we'll have just a couple minutes here in transition between lawyers for the next case of White versus Harkrider et al.